Hello and good afternoon. Welcome to our Wednesday webinar. Bucket Long is offering a series of fortnightly webinars on a range of different different subjects for individuals, families and businesses. My name is Suryen Nullatamby and I'm a senior associate here at Bucket Long. This week we are looking at the Construction Act 25 years on. Success or failure. I will take questions at the end, so please do make use of the question and answers facility at the end. Thank you. Yeah, I'm a qualified barrister solicitor. I'm also, by way of introduction, I'm an accredited adjudicator and arbitrator. I specialize in construction disputes, resolution and adjudication, with a focus on payment disputes, delay and disruption claims, defective designs, workmanship, and I also deal with professional negligence claims. I've been here at Bucket Long for nearly a year now. I'm also an accredited adjudicator. I sit on various UK panels, the CIR, Chartered Institute of Arbitrators, the Construction Industry Council, the RICS, and the UK Adjudicators. Like I said, the next slide, please. The topic of today's webinar is the Construction Act 1996. It's been 25 years since the enactment of the Act. What I propose to do is to just run through what I'm going to be talking about today. First, I'm going to deal briefly with the background of the Construction Act, what changes it brought in terms of construction dispute resolution for the past 25 years, how it was enacted, and where we are now today, whether, you know, the Construction Act has helped resolve payment disputes, and also whether it helped manage unlocking cash flow for parties. Next slide, please. So what is the purpose of the 96 Act? The 96 Act was, it's been now 25 years. The Act is known as the Housing Grant Construction and Regeneration Act 96. It didn't come into effect until the 1st of May 1998. It was introduced, firstly, in response to the report and recommendations of Sir Michael Latham, which was commissioned in July 93 to review the procurement and contractual arrangements in the UK construction industry. His final report, called Constructing the Team, was published in July 1994. And as such, that's how the statutory regime of adjudication came into effect, was formulated into the 1996 Act. It provided two ways of unlocking payments. One, it's provided a series of payment provisions, which requires timely notices to be provided about the amount to be paid by a payer to a payee. And also it provided a dispute resolution process of adjudication, which enables any type of dispute, for example, valuation, to be resolved on a temporarily binding basis. Adjudication of construction dispute was, as Lord Briggs put it in his the case of Bresco Electrical Services Limited and Michael J. Longdale, dated 17th of June 2020, adjudication of construction dispute has been a conspicuously successful addition to a range of dispute resolution mechanisms available for use in what used to be an over-adversarial litigious environment. So before the Act, what happened was you got an independent certifier. You were enabled, you didn't have the mechanism to go and challenge a certifiers or a certificate. And that has been provided now by adjudication. Next slide, please. So what is a statutory adjudication? The Housing Grant Act, which is the main part legislation I've just mentioned, it requires a construction contract to contain payment provisions and the right to adjudicate any dispute. So if the Act applies under Section 108, a party to a construction contract has a right to refer a dispute or any difference to adjudication at any time. If the provisions of the contract does not comply with the Act, then the relevant provisions of the scheme for construction contract applies in default. That is, they take effect as implied terms of the relevant contract. And on your screen, you will see that's what we call the amended scheme for construction contract in England and Wales Regulation 1998. The reason it's been amended is there have been since 2011 some amendment brought to both the scheme and the Act. For example, the construction contract doesn't need any longer to be in writing, so a contract can be oral, or partly in writing. And the scheme also contains a detailed procedure for the adjudication process. So the right to payment and to adjudication is guaranteed by the Act. The right is there, so the parties have the options of whether to use adjudication or not, but a party cannot contract out of the Act. However, if the Act does not apply, for example, certain types of contracts like PFI contracts or power plants, then the parties may agree that the Act will apply to their contract. So when does it apply? The Act applies to any construction contract that involves the carrying out of construction operations in England, Wales, and Scotland. And the Act broadly covers most building and engineering contracts, with certain exceptions. Section 104 of the Construction Act defines a construction contract as an agreement for the carrying out of construction operations, the arranging of carrying out such construction operations, provision of labor or the labor of others for the carrying out of construction operations. But there are specific exemptions or, that are excluded, like I mentioned earlier, during of oil PFI contracts. The second part of the definition in Section 104, which provides for construction contract, includes an agreement to do architectural design and surveying work, to provide advice on building, engineering, interior or exterior decoration, or the laying out of landscape in relation to construction contracts. Now, residential occupiers are actually expressly excluded by Section 06 of the Construction Act. It means that a person, an individual who occupies a residence, have their work done, they can neither bring an adjudication for defects, claim, or any issues with valuation. And in the same way, any contractor cannot take any dispute with a residential occupier to adjudication. However, I must say there are some forms or contract standard forms, such as the JCT minor works, where they accept adjudication as a mean of resolving disputes between a residential occupier and a contractor. Now, next slide, please. If the Act applies, like you see on this slide, any party has a right to refer a dispute to adjudication at any time. Next slide, please. The scheme, just a few words on the scheme. The statutory instrument was introduced as a secondary legislation to the Act. And like I said, it was amended by an Act in 2009. It contains detailed procedure for the adjudication process, from the giving of the notice to the right to the appointment of the adjudicator, including the making of submissions and through to the enforcement of adjudicator's decision. Next slide, please. So what adjudication does is actually the process of dispute resolution is you refer the adjudication, your dispute, to a third party, and generally that could be a lawyer or a qualified expert, and that person is then appointed or nominated either by agreement of the parties or by an adjudicator nomination body, and they make a quick decision when the parties are in disagreement. Next slide, please. The process of adjudication is normally you have to provide a notice. Like I've mentioned, it's a that's provided in the scheme. You provide a notice of adjudication to a responding party, and usually as soon as you've provided the notice, you then go on to appoint a request for the nomination of an adjudicator. And the nomination body normally goes and select an adjudicator who's got the expertise, the experience to deal with that particular dispute in terms of value or the complexity. Once the adjudicator has been appointed, that's when you can refer a dispute to the adjudicator. Normally there's about 7 days. A maximum of 7 days between the notice and the referral being made. If you miss that deadline, then one has to start again. Otherwise, the referral will be invalid. Usually, once the dispute has been referred to the adjudicator then has an obligation to deliver his decision, to publish his decision within a 28-day period. This is provided, this is a statutory requirement, and then usually the adjudicator will proceed to make his, provide his directions or set out a timetable by which the parties will be making submissions. There are various level of submissions. Starting from the referral notice, then the responding party will serve a response. Usually the adjudicator can make directions or grant permissions to a referring party to serve a reply on new matters in order to make responsive submissions to the response. The 28-day period limit can be extended by the referring party up to unilaterally up to a maximum period of 14 days, taking the length of the adjudication to 42 days. However, sometimes if the parties really want to resolve their dispute without any further issues between the parties dealing with the timetable, the parties tend to agree with the adjudicator to extend the period that's required for the adjudicator to make his decision or his or her decision. Next slide, please. I'm going to touch on the process of post-adjudication. So once the parties have obtained a successful adjudication decision, say it's, for example, it's a money award, usually an order would be made that the losing party would have to pay the winning party the award forthwith or within 7 or 14 days as decided by the adjudicator. But what happened most of the time, not most of the time, sorry, on occasions where an unsuccessful party may refuse to comply with the decision, then what the successful party can do is to go to court and enforce that decision through a special fast-track procedure in the technology and construction courts. Most high-value cases will go to the High Court, and depending, there are various regional where some enforcement application or proceedings may be lodged in regional courts as well. They are it is very rare for the court to not to enforce a decision, because the court is pro-enforcement and promote the whole objectives of the Construction Act, in that they usually say pay now and argue later. There are very, very exceptional grounds when a court will interfere either with an adjudication decision at enforcement or even during the course of the adjudication. And that could be, I've listed a few examples of bias, conflict of interest between the adjudicator or any of the parties, or if the adjudicator has exceeded his or her jurisdiction. What by that I mean is the adjudicator has not answered the correct question that's been asked of him or her. Where the adjudicator had no jurisdiction, for example, the contract upon which the dispute has been referred to him or her is not a construction contract, or his nomination was not done correctly. Just to give an example, there are cases where an adjudicator, a contract says that an adjudication nomination body would be the RICS, but an application has been made to a different nomination body. And in those instances, yes, the adjudicator would not have any jurisdiction. But in most cases as well, adjudicators, if any challenges have been brought, or jurisdiction challenge have been brought within the adjudication, the adjudicators tend to resign at that stage. Also, there are certain decisions, which is very rare, that I've seen, where there's no clear decision that's been reached that is capable of performance. If there are allegations of illegality, for example, bribe, and finally, if there's been breaches of natural justice. There are, I mean, in 25 years, there's a huge body of case law dealing with breaches of natural justice. But in recent times, my view is most adjudicators, mostly trained adjudicators, they do proceed with adjudication by giving parties, the opportunity and the time to make submissions, and carefully ensure that the rule of natural justice is maintained. Next slide, please. So one thing I want to say is, do we consider whether the objectives have been met? By that I mean, even in certain cases in court, some judges, like Lord Justice Coulson, have said that, in 25 years, we think that broadly the Construction Act has helped the construction industry. There has been many successes and possibly some failures in the view of some people, but it's generally recognized, which I will quote from Lord Justice Coulson in the case of C. Spencer Limited and MW High Tech Projects Limited. It's a civil 2020 case. He says the Construction Act and the scheme was to improve cash flow in the construction industry and to streamline its dispute resolution process. The former aim was achieved through mandatory provisions relating to interim payments, payment notices, and the like, and the latter through a new compulsory scheme of construction adjudication. The Act has been, on any view, a considerable success. And he does recognize that the Act is not as comprehensive as might have been. But what the Act has achieved actually is it has helped, it has allowed cash to flow quicker. There are thousands and thousands of disputes that are resolved either pre-adjudication now or through the whole adjudication process. It's quick, and they're very rarely, very unusual to have a face-to-face hearing. Most of the adjudication are determined by way of documents on paper only. If there are hearings, any adjudicator want to clarify anything with the parties or the experts. In the last couple of years, there's been a new trend of having remote hearings, and that's far quicker to get, rather than getting people to travel between centres. And it's been proven that it's significantly cheaper than litigation and arbitration. By that, I don't mean adjudication is cheap, but it's far cheaper than litigation and arbitration. And like I said, there's a huge body of case law that's been around for the last 25 years, and which governs the whole adjudication dispute resolution process. Next slide, please. Before I run taking questions, we will be sending a recording round to everyone that signed up to today's webinar tomorrow morning. We will also include a link to very short feedback survey. We would really appreciate it if you could complete that so we can make sure our future webinar are helpful to you. As I've said at the start, this is one of the series of Wednesday webinars. Our next webinar is Sustainable Strategies. Great for your business and not just for a lot of hot air, for business owners and directors on 3rd of November. If you are interested in our future webinars, please visit our website or our Eventbrite page to sign up. Next, I will take some questions. Thank you.
Thank you for that. We've got a couple of questions that have come in for you. The first one is, what means exceeding and no jurisdiction?
By that is, if an adjudicator has been asked, let me answer the no jurisdiction at all. Like I explained, sometimes an individual can be referring a dispute to an adjudicator on a contractual dispute. If, for example, that contract is exempted from the Act, for example, a residential occupier, an adjudicator will not have jurisdiction. And the second example I've already given earlier is when an adjudicator has been appointed by the wrong nomination body, for example. If the contract provides for a particular name adjudication nomination body and the referring party has gone to a totally different one, it means the adjudicator does not have the jurisdiction to make a determination of that dispute. A third example is, I think I've already mentioned residential occupier. In terms of exceeding, if an adjudicator has been asked a question in the referral notice, if they go on a frolic on their own, they go and try to do some independent work without about something that has not been asked of them, either by the referring party or the responding party, that's when we call it they've exceeded their jurisdiction.
Thank you. The other question that we've had is, Do you think residential occupiers should be allowed to commence an adjudication or continue to be excluded from adjudication?
Well, I was going to touch on the residential occupier. At the moment, as it stands, Section 106 exclude residential occupiers from having the benefit of the Act. There has been two school of thoughts about this. There's one school of thought we think, the Construction Act now can be amended. There are prominent judges who even think that why not bring residential occupiers now within the Act and give the right to these people, what I mean parties as residential occupiers or even contractors, the right to go to adjudication. In my own experience, there have been cases which have been referred to against residential occupiers, and there are cases where you will have to, the residential occupier doesn't have any choice but have to go to litigation or arbitration, which is very costly. I think what we've seen already, the success of adjudication is there. Like Lord Briggs put it in the Bresco case, he says a very important underlying objective, both of adjudication made or other recommendation which were eventually implemented in the 96 Act was the improvement of cash flow to fund ongoing works on construction projects. So if a contractor has a payment dispute, that means they will have to go and have lengthy protracted dispute with a residential occupier so there's no chances of resolving those payment dispute. But if we get rid of that exemption, yes, I think it should be brought in to give that right to residential occupiers or as well as contractors. Yeah. Any more questions?
That's all the questions that we have for today. Thank you very much.
Yeah, thank you for joining us today, and we will review any questions. And if you need to contact me, my email address is on your slide, suryen.nullatamby@burkettlong.co.uk. Thank you.